अगर आप ये वीडियो हिंदी में देखना चाहते हैं तो ये वीडियो हिंदी में भी रिकॉर्ड किया गया है। डिस्क्रिप्शन बॉक्स में दिए गए लिंक पे क्लिक कर सकते हैं। धन्यवाद। Hello and welcome. Today I will be discussing a very important aspect of family law, that is divorce by mutual consent. To begin with, let us understand the kinds of divorce available in India. Firstly, there is a simple divorce, which is also called as a contested divorce, wherein only one party, that is either the husband or the wife, wants a divorce against the other party. So in this kind of a divorce, there are two parties which are fighting against each other in the court, and this is no different from any other case that is filed in the courts. Second kind of divorce that is available in India is divorce by mutual consent. Now, what exactly does divorce by mutual consent? What does that actually mean? So, going by the term, the phrase itself, it means mutual consent. That is, both the parties mutually agree by free will or consent, without any kind of force or fraud acted upon the other party, that they want a divorce. So basically, the entire essence of divorce by mutual consent is consensus amongst the two parties to take a divorce. Today we will be discussing about divorce by mutual consent under the Hindu Marriage Act 1955. Now, because divorce is a personal law matter, in India, personal laws for every religion, that is, every religion has its own different separate legislation. So, for Hindus, there is the Hindu Marriage Act, Parsis, there is another act, Christians, there is another act. We'll go into detail about it maybe in some other video later. Today we'll be discussing only about the Hindu Marriage Act. So let us see who all are covered by the Hindu Marriage Act. Unlike the name Hindu Marriage Act, it does not govern only Hindus, but it also governs Jains, Sikhs and Buddhists. So for example, if there is one Jain and one Sikh, or by that I mean either the husband is a Jain or the wife is a Sikh, or both husband and wife are Sikhs, both are Buddhists, or maybe both are Hindus, in that matter they will be governed by the Hindu Marriage Act 1955. Now, divorce by mutual consent was not in the original act of 1955. It was brought by an amendment in 1976. So now, let us see which is the section that governs divorce by mutual consent. So it is section 13B, that is 13 capital B. Now, what are the essential ingredients, or what does section 13B actually say? So section 13B says that a petition for divorce may be presented to the district court by both the parties to the marriage together. So this petition has to be filed by both the parties together, that is the husband and the wife. There is a single petition, and the ground, there is only a single ground. So what is peculiar to divorce by mutual consent is that you require no specific ground other than the fact that they have been living separately for a period of 1 year or more, that they have not been able to live together, and that they have mutually agreed that the marriage should be dissolved. Now, these are the three basic things which need to be satisfied before you file a divorce under section 13 capital B. So, first is that they have been living separately for a period of 1 year or more. Now, what exactly this means is, firstly, it shows that the fact that the two parties have been staying separately from each other, this fact shows that the two parties actually cannot stay with each other, which shows kind of a breakdown of marriage, and that they don't want to actually stay with each other. Now, what is essential for this condition to be satisfied is that the period of 1 year must be immediately prior to filing of the divorce petition. So for example, a marriage has lasted for 15 years, say for example, and the husband and wife, for whatever reason, stayed separately from each other for a period of 1 year, more than that maybe, but 10 years before the filing of the petition, maybe in the 5th year of their marriage, that will not be counted as staying separately, because for the purpose of section 13B, the two parties, that is the husband and wife, must be staying separately for a period of 1 year or more, which is immediately prior to the filing of this petition for divorce. Secondly, what is also, which probably for the common man to understand, is that these parties, they need not stay in separate houses, unlike what probably a common man would understand from reading the bare section. They need not stay in separate houses. They can stay under the same roof, but what is important is the intention, not to stay as husband and wife. They need not have the intention, they should not have the desire to perform marital obligations. They may live under the same roof, but they may not be living as husband and wife. And the intention to live separately, that is, live other than as a husband and wife, that is important. Now, this petition, which is presented before the court by both the parties, that is, the husband and wife, is called as the first motion petition. This petition is filed by both the parties. Parties are husband and wife. They are not opposite parties, so it's not a petitioner and respondent. They are petitioner number 1 and petitioner number 2. Now, question comes whether just by filing this one petition before the court is the divorce final. No, you need to file a second motion before the court. This is called as a second motion petition. Second motion basically, which is exactly similar to the petition which is filed as a first motion petition. Contents are exactly the same, other than the fact that your dates will be a little different, and you'll have to specify that you have already filed the first motion petition. Now, what is the time limit for the second motion? Second motion cannot be filed just any time. As per the Act specifically says it can be filed only once you complete 6 months from the date of filing of the first motion. Now, as per the Act, there is also an outer time limit, which is that you cannot keep it pending. This first motion petition, you cannot keep it pending for an indefinite period of time, basically. So there is a time limit, and you cannot therefore file the second motion petition anytime after completion of 18 months from the date of filing of the first motion petition. So, for example, if I say I have filed the first motion on 1st of January 2020. So I cannot file the second motion before 1st July 2020. That is completion of 6 months. I cannot file it within this period of 6 months. And I cannot file it any time after 18 months from the date of filing of the first petition. That is from 18 months from 1st January 2020, which is 18 months will be completed on 1st July 2021. 18 months. So I cannot file a petition for the second motion after the completion of 18 months from the date of filing of the first petition. Another interesting aspect about this is that coming back to the 6 months gap. Now, the 6 months gap, as per there's been a recent Supreme Court ruling which says that the 6 months gap is not mandatory, it is merely directory or discretionary. So now if after this Supreme Court ruling, you will have to seek permission from the family court, the district court, where you have filed the divorce petition, specifically seeking the court's discretion that you need not file the second motion petition, or that this gap of 6 months may be waived off, and you can file probably a second motion immediately within 1 week of filing the first motion. That is completely on the discretion of the court, and an application needs to be made to this effect, seeking a waiver from that specific court where you have filed the first motion, that the 6 months gap be waived, or that the second motion should not be filed. Now, this is only in very completely to the discretion of the court, and the court needs to be satisfied that circumstances such that second motion need not be filed. The court should be satisfied that the husband and wife they have completely decided that they want to stay with each other, or that there has been a completely irretrievable breakdown of marriage. Now, why was this 6 months gap? Someone may ask, why was the 6 months gap introduced? Now, the 6 months gap is actually called as a cooling off period. Now, why was this introduced? Is basically considering human nature, that people cool down, calm down after a period of time. They probably try to resolve their disputes, misunderstandings. They try to reflect upon whatever has happened. Probably families intervene and things cool down. So basically, the intention behind introduction of the 6 months gap was, at the time, this was the original. It was introduced with the main provision. So why it was introduced is just with the aim that marriages, as much as possible, should not be broken down. You should try to maintain the marriage as much as possible. Now, another very interesting part is that within this, from the date of filing of the first motion to the date of filing of the second motion, any one party can withdraw from the divorce petition, seeking permission from the court, of mentioning to the court that I don't want a divorce for whatever reasons. Now today I am not willing, I don't give my consent for a divorce. This can be filed by any one of the parties, or in fact even both the parties, stating before the court that, my lords, I do not want to take a divorce. Maybe the 6 months cooling off period has worked, that they have reconciled their differences. So in that case, both parties will come, or probably one party comes up. Now, a lot of times, force has been, acted upon by one party. Sometimes, you blackmail another party, stating you have to take divorce from me under mutual consent. And within the span of 6 months, sometimes what happens is the other party realizes that, no, I cannot be acted upon by force, and it may come out to the court and say that force was acted upon me, it was coercion, and therefore my consent was not free will. So a lot of instances can happen when you can actually withdraw from the mutual consent divorce. This can be done only till the expiry of 18 months, not later than that. Now, a very common question that crops up is, what if you have already, the one party has already filed a case for divorce, and now both the parties agree that yes, now both the parties want a divorce. So what do you do in that situation? So usually what happens is, both the parties, they will file a petition for mutual consent before probably the very same court where this previous divorce petition, which is a contested divorce petition, has been filed. This first motion will be filed, and maybe on that same day, or whenever the original contested divorce petition has been filed, you can seek withdrawal of the contested divorce petition, which is filed by only one party, and you can continue with this divorce for mutual consent. The only thing is, you need to file a specific petition seeking divorce by mutual consent under section 13B. Now, another very common question that comes up is, can I file divorce by mutual consent through the same lawyer? Can both the parties be represented by a single lawyer? For whatever reason, maybe financial reasons, to avoid confusion or whatever, yes, definitely, one lawyer can represent both the husband and wife. You need not engage two lawyers, that is, and it's just more convenient. Same one single petition goes, it's signed by both the parties. Now, what should be the contents of the divorce petition? It is very important, amongst various other formalities which need to be mentioned. I will specifically advise that you should mention the terms of settlement, which would include the alimony, the maintenance, or maybe the custody of the child. Now, the reason for mentioning all these at the time of the filing of the divorce petition is, one, that you get a stamp of the court on the terms of settlement, so you don't need to go to the court again and again for small issues, fighting for small issues like maybe the custody of child or for maintenance. You don't need to go to the court, otherwise the entire essence of seeking a divorce by mutual consent goes away. Why? Because you're again fighting in the courts, and the judicial system definitely takes time. Second reason also for mentioning the terms of settlement, either you mention it or you annex it along with your petition as a separate sheet that these are the terms of settlement. So another reason is also that a lot of times what happens is when you have already been granted a divorce, a lot of your rights as husband and wife get extinguished. So try and uh, make the most of the terms of the reconciliation or terms of settlement amongst each other till the time your rights as husband and wife are alive. Another question that crops up is what are the kinds of documents required? Now, it depends from state to state because each high court has a different rule. But generally speaking, these are the kinds of documents that you will require to attach along with your petition, first motion and second motion. So, marriage certificate, which is a proof of marriage, photos of both the parties, passport size photograph of both the parties, marriage photograph, one or two maybe, terms of settlement if any, ID proofs of both the parties, address proof of both the parties. Majorly these are the documents that you will require to attach along with both the petition, both the motions for divorce. Now, very important, another aspect which should be mentioned is that both the parties must be present at the time when the matter is listed in the court. So a reason for this is because court will definitely, record the statements of both the parties, that is the husband and the wife, and a statement will be recorded by the court. It will be printed immediately by the court. It will have to be signed by both the parties then and there before the court. So therefore, both the parties must be present both at the time of first motion and at the time of second motion. In very exceptional circumstances, it is possible that one party cannot come. In such a circumstance, probably definitely it is on the discretion of the court. If the court allows your absence, if it allows this to happen, you are supposed to authorize one particular person who is very close to you, maybe a family member, by way of a power of attorney to represent you in the court. Now that person who has been authorized by you to represent you in court has to be present in court along with the other party. Another very important question that comes up is, just by filing the first motion, is your divorce final? No, your divorce is not final just by the filing of the first motion. Second motion has to be filed unless and until it has not been waived off by the court specifically. Now, most of the aspects of Section 13B have been dealt with. Coming to the next very important section is Section 14. Now, Section 14 is not specifically only with respect to Section 13B, but it is also with respect to Section 13, that is a normal kind of divorce, a contested divorce. So generally it applies to both the sections. Now, what does Section 14 actually speak of? So Section 14 says that unless you have not completed 1 year of marriage, the court will not entertain your divorce petition. So according to Section 14, once if you have not completed 1 year of marriage, you cannot file a divorce petition, whether it is divorce by mutual consent or it is a contested divorce which is filed by only one party. Now, Section 14 carves out an exception by itself, which says that in cases of extreme or exceptional depravity on part of one of the parties, that is usually, in case of a normal divorce respondent, or in case of exceptional hardship caused to one of the parties, the court may allow a divorce petition to be filed, but that has to be in accordance to the rules made by the High Court in this behalf. So only if a rule of the High Court allows this will the District Court, falling under the jurisdiction of this High Court, allow a petition to be filed before you have completed 1 year of marriage. So suppose I got married on 1st of January 2020, I cannot file any kind of divorce petition before completion of 1 year from the date of my marriage. In the case of divorce by mutual consent, what happens is you cannot file a divorce, any kind of divorce, before completion of 1 year of marriage. So till January 2021, I cannot file anyways a divorce for mutual consent. Now, Also, you need to keep in mind that you have been staying separately from one another for a period of 1 year or more. That also needs to be kept in mind while filing the divorce petition. Secondly, another very important aspect is section 19, which talks about jurisdiction, which is a very common question as to where are you supposed to file the divorce petition. So section 19 lays down 5 places where you can file your divorce petition. This is again a general section which applies to section 13 as well as section 13 capital B, that is divorce by mutual consent and a normal divorce. So let me read it out. First place is where the marriage was solemnized. So wherever the marriage ceremony took place and the court, you can file a divorce within jurisdiction of that court wherever your marriage ceremony was solemnized. Second place is the respondent at the time of the presentation of the petition resides. So in this case, since there is no petitioner, there is no respondent, there will be both are the petition number 1 and petition number 2. Therefore, where either of the party resides, you can file the divorce petition. Third point which says is parties to the marriage last resided together. So this is important, is where the parties have resided together. So wherever they last resided together will be counted as a place where you can file a divorce petition. And the next one says in case the wife is the petitioner, where she is residing on the date of presentation of the petition. Again, in this case, in the case of divorce by mutual consent, like I said in the previous point, that it can be filed either where the husband or the wife resides. Fifth point is the petitioner is residing at the time of presentation of petition in certain specific cases. But again, this subsection 4 will not apply, reason being that both the parties are mutually consenting and there is no petitioner and respondent. So you can file it either where both the parties are residing, either of the parties are residing, or where they last resided together, or where the marriage was solemnized, or that is where the marriage ceremony was solemnized. So these are the basic points that I have covered about divorce by mutual consent. I hope you found it to be informative. Thank you so much for watching.